Some screen sharing. Okay, welcome everybody to the Power of Attorney and your escrow. On the line today, I have with me our sales team consisting of Robin Albert, Linda Federico Johnson, Brad Fisher, and Val Allen. Lisa Williams could not be with us today, but she is available for any post seminar questions that you might have. And we are excited to have escrow officers Christy Kutka and Loveneet Bains as our instructors today. So without any further ado, we will launch right in. Take it away, Christy and Love.
Morning, everybody. How are you guys? You ready for some fun? We're going to talk fast. We're going to talk real fast because there's a lot of information to cover in a fairly short period amount of time. Yeah. So Love and I are a team here at Chicago Title, and we work with a bunch of amazing women, and we run into all kinds of fun things regularly. And one of the most exciting things we run into is working out what works with a power of attorney. So let's start off with what a power of attorney is. And that is a document that allows somebody else to sign on your behalf. Okay. So it's a document that traditionally gets recorded. And, you know, let's talk about what we're going to cover today. So these are the items right here that we're going to cover.
So there's several different types of power of attorney. We're going to go over the ones that will be most useful to you and your clients in your transaction when it comes to real estate documents. We're also going to cover when and why someone may want to use a power of attorney. There can be a variety of reasons, so we'll go over those. Our company has various underwriting policies and guidelines that we have to follow in order for us to be able to accept and be able to use a power of attorney. So we'll go over some bullet points on that. How long is a power of attorney valid for, and who needs to notarize the document. So those are the points that we're going to be touching on today.
So let's talk about when and why a power of attorney might be needed in your transaction. So we have a couple of different things. The party might be leaving the area. So if they're leaving the area and we want to make sure that the escrow transaction runs smoothly, we want to get this document that allows somebody else to sign on their behalf.
An example of that can be, someone is traveling to Hawaii, and sometimes it's a little bit harder to find a notary there or to get documents shipped back. We had a client not too long ago. They were in the National Guard, and they weren't just going to be available to be able to sign. So even locally here, it doesn't necessarily mean that you're leaving the country, but even if you're still in the United States, we can still prepare power of attorney for you to be able to have someone else sign on your behalf.
Mm-hmm. So a party to the transaction is unavailable for signing. So we have that right there. And then the last one is that the customer is incapacitated. So you have to think ahead of the game when it comes down to using a power of attorney. You can't a lot of times just say, oh, they're out of the country, let's get a power of attorney signed. You can, but sometimes it gets dicey when that happens. So it's always better to be thinking in advance, especially when we start talking about being incapacitated. Because when you're incapacitated, you can't be incapacitated and signing the document. You have to be in the beginning stages or the thought that it might be happening in the future.
So example of incapacity, you're in the hospital and you're physically, you just can't sign. Mentally, older people who have early stages of Alzheimer's or things like that, that qualifies for incapacity as well. Usually within, when we're using a power of attorney and it falls under incapacity, we will ask for 1 or 2 doctor's notes. Sometimes the power of attorney will list how many doctor's notes, or if the power of attorney is accompanied by trust documents, it'll mention how many doctor's notes might be required. Our company typically requires 1 unless 2 is specifically stated within the document itself.
Mm-hmm. So let's talk about the different types of power of attorneys. So there's two that we traditionally see here. We see a general, and we also see a specific. So a general is not specific, obviously, to our transaction. It is a general one, and then it lists a variety of things that the person who is signing on behalf is allowed to do. Go ahead.
So some examples of that, being able to open a bank account, to being able to sign real estate documents. Some will even say, you can sign a contract, but you can't sign the deed. So it has to be it will list all the requirements, all the things that you can and can't do when it comes to using that power of attorney. So it'll give a list, you either initial next to which item, or usually down towards the bottom of the power of attorney, it'll say it applies for all items. So that's something to look for when your client presents you with power of attorney that they have prepared.
Yeah, and so the next one is a specific, and that is one that we can draw here at Chicago Title. So it is not uncommon for us to receive a phone call that says, hey, our guy is leaving the country. Can you draw a power of attorney that allows his brother to sign on his behalf? What happens is we get the address of the property, we get an expiration date, we find out who is going to be signing on his behalf, and then we run with it from there. So both documents can be used, but we also have to have some approvals that go along with those.
With the specific power of attorney, that power of attorney only applies to our transaction, specifically for real estate documents. And again, it, like Christy mentioned, we usually do put an expiration date on it to show how long it's valid for. And an example again here, we actually just had a client last night. They said that they're going to be leaving the country and they have 3 properties that they're looking to sell. So we pre-opened the escrows for them, and we're able to prepare the power of attorney before the client left the country. So they were thinking ahead, and we were able to help them.
And the good news about using a power of attorney is it allows somebody else to sign on your behalf, but it does not eliminate you from the transaction. You still can be an active participant in the transaction. So what we would do is we would send all the documents still to the customer for their review, but it allows somebody else to sign for them.
Just makes that process a little bit easier, because when it comes to having documents notarized in another country, which we will talk about here in just a little bit, it can get kind of difficult. And especially right now, because of COVID, there's a lot of restrictions, and embassies aren't necessarily taking appointments for all types of notarizations. So when you have especially when you have someone leaving the country, it makes it a lot easier if there is someone here in the United States to be able to sign for them.
So,
Love and Christy, you already have a question in the chat, and that is, does the specific POA cover trust? Does the trust have to specifically state the power of attorney, that the power of attorney is allowed?
So yeah, we're going to get to that, but traditionally speaking, power of attorneys and trusts do not go hand in hand unless specifically stated within the trust. And I think I've only seen it a handful of times in my career that allows for a power of attorney to be used. So that's a whole nother layer, but we'll get to that in just a second too.
Perfect, thank you.
So let's talk about the guidelines for use and acceptance.
So as we were mentioning earlier, the document does have to be specific. We look for very specific language within the document that says that the client has the authority to be able to sign real estate documents. Someone presented me with a power of attorney just the other day, and the power of attorney said that it can be used to sign the real estate contract. So it's only valid for the contract, not for our escrow papers, not for the deed, not for any loan documents if the customer was purchasing the property. So that's the type of things that we look for. So it needs to be very specific with saying that it can be used for real estate transactions to buy or sell.
The next one is that we look and see how old the document is. So we're not going to generally accept a power of attorney that was drawn in 1952 without getting some background about what's going on here. So you got to understand, a lot of these guidelines are not because we're trying to be difficult. We want the escrow transaction to close, but we also want to protect the consumer. And a lot of times people are thinking on the lines, oh, they're just being difficult over there at Chicago Title. But the bottom line is that we're just trying to make sure that the document is valid, because at the end of the day, something could have happened since 1952 and now, and just because you produce it doesn't mean that it's valid. So the next one is that, when was it signed? Do the signatures match? So what we're going to do is we're going to go back through and we're going to make sure that the document that was signed, that's being presented to us, this power of attorney, that possibly the signature matches the deed that was originally signed in the first place.
So when we have really old powers of attorney that we're using, let's say even 5-6 years, it can be said that that's kind of a little bit of an older document. We will go back through any previously recorded documents to try to compare signatures. This is just an extra measure that we take in order to try to be able to use the power of attorney. So if the customer is available to be able to tell us that, yes, they understand that the property is being sold, if we can speak to them, that makes things 1,000 times easier. But if you have someone, for example, who may have Alzheimer's, or they're in a home and they can't handle their own affairs, that's where we don't want to have to reach out to the customer, but we try to take extra measures to be able to accept the power of attorney. So that's where we will compare signatures and see if it matches previously recorded documents.
We want to know why the power of attorney is being used, and sometimes it does mean that's when we get the doctors involved. That's when we're just doing the extra digging to make sure that we're protecting the customer, because the last thing we want to do is sell a piece of property that this person did not have the right to sell. So the next thing is, the last one is that we're going to make sure about the notary. Now, this is a big hang-in deal lately. So go ahead.
So our company has notaries who get approved they get vetted through our company. If we're going to use a notary, we have various guidelines that they have to meet. They have to be a notary for a certain amount of time. They have to submit the proper documents. They have to have proper insurance. So that's another thing that we look at when we're reviewing a power of attorney. If the power of attorney is notarized by someone who is approved with our company, it's just another thing that helps with the process of getting the document approved. So if you use a Chicago Title approved notary to have your client's power of attorney notarized, that's just another bonus that makes us want to approve it more. So just another thing to think about when the use of the notary. So is the signing taking place out of the country? Now, it's much bigger than just our company policies. It goes further on with the recorder as well. When you have a document that's notarized in another country, the Fresno County Recorder's Office won't accept that notarization by a foreign notary. It has to be done by either a U.S. notary, obviously any notary within the United States would be able to notarize a document, or a notary at a U.S. embassy. So that's still U.S. soil, it's still a U.S. notary. And that's where recently, especially, we have run into a couple of customers who aren't able to get appointments at a U.S. embassy. So because they are out of the country and because of COVID, those restrictions at the U.S. Embassy's office, it has prevented some of our transactions from being able to go through. One of our customers, they are right now in India, and he tried to get an appointment to have his power of attorney notarized, but unfortunately, with COVID and other things that are going on there, he's not able to get an appointment at the U.S. Embassy. So he's actually having to come back into the United States before he can sell the property.
Yeah, this is when you're taking a listing and people are presenting these documents to you or telling you what their plan is. This is when it's super important to fall back on your escrow team. So especially, on day one, before you've accepted an offer, that's when you want to make the phone call. I received a phone call last week about, this gentleman had added his husband to title, and his husband is in a different country. And I mean, we're running into all kinds of issues. The fact that he can't get an appointment there to get it notarized. So he's going to come back to do an interspousal deed to be taken off of title. So he's not even a part of the transaction. Mm-hmm. So it's really important. Had he not asked me that question, it would have been a disastrous escrow process. And he made life a whole lot easier by having the conversation now instead of later. Mm-hmm. So the next one is how long is a power of attorney valid? Well, it kind of depends. So it's a case-by-case basis. You know, why are you using the power of attorney? Is the person aware that it's being used? You know, is there an expiration date? All these things kind of play into how we're going to be making these decisions.
So general powers of attorney usually do not list an expiration date. So if you go to an attorney, a paralegal, they don't typically put an expiration date on a general power of attorney. If you come to us, we will put an expiration date on that power of attorney. And again, when we draw a power of attorney, it's very specific to only our transaction. It can only be used for real estate documents and the escrow paperwork. So if you try to take that power of attorney and open up a bank account with it, it's not going to happen. So that's where consulting with an attorney or a paralegal is advisable here, because if there's other things that you want to be able to do with the power of attorney, then you may need to seek help from somebody else in order to have that document prepared.
Oh, so
powers of attorney and trust. Typically, the answer is no, because a trust is set up in order to allow for someone else to sign on your behalf, or excuse me, for someone else to be appointed as a successor trustee if you are unable to sign due to death or incapacity. So within the trust, it will list who is going to sign next if you're incapacitated, and what the requirements are to be in order to appoint that person as successor trustee. So as we were talking about earlier, you can get doctor's notes, the other trustees can sign off on it. The existing trustee can appoint you as successor trustee. So it varies trust by trust, and that's where it's important for us to review the trust documents to make sure that the guidelines listed within the trust, which were the desire of the customer, are being followed. So yes, sometimes you can use a power of attorney. I personally have seen it one time ever. I haven't been doing this as long as Christy though, and I'm sure
Hey, this is where she goes down the road.
And she
hurts my feelings.
And she can attest to the same thing. It's very rare for us to see that a power of attorney can be used in the capacity of someone as trustee of the trust. So that's where, again, it's very important for us to review the trust paperwork. And just because the clients say, oh yeah, I have power of attorney, I can sign on their behalf, it is very important for us to review the documents and make sure that the trust can actually allow for that to happen.
So when you are taking this listing and somebody presents you with a power of attorney, please immediately turn it over to your escrow team. Have it reviewed. Have the title facility review it. Please also tell the customer that we are going to need the original document. If it has not been recorded in Fresno County, it will have to be recorded here. Not a copy, the original. And a lot of people, what they don't realize is that they're like, oh, here's the document, the copy right here, and we don't have to worry about presenting anything else. It will have to be recorded, and we have to verify the validity of it. So, please fall back on your escrow team.
That's what we're here for.
Yeah. And the good news about getting it reviewed in advance is that it just makes your transaction smoother. It just makes you guys look like the hero that you guys are. So fall back on your team.
Christy and Love, we focus mostly on the seller needing the power of attorney, but what special circumstances do you run into where it might be a buyer And how does that coordinate with loan docs needing to be signed and things like that? What is allowable and involved in that?
So we get calls regularly from lenders saying that the customer is leaving the country, and we have zero problem. We can draw up a power of attorney fast, like super fast. Like if you called us right now and like if the customer was sitting out there and needed a notary, we could have this thing done in 10 minutes. I'm not kidding. It's fast. But here's the thing. The lender has got to approve it. So where we have zero problem drawing it, we have zero problem accepting it because it's our document. The lender also has to take it to underwriting. So I had one just recently where they did not take it to the underwriter. So when the loan documents came out, it didn't have the specific power of attorney verbiage that is supposed to be on all the signature lines that go along with this. So you got to go down this road. So what we do is get it drawn immediately, send it to the lender, and have the lender send it to the underwriter also for approval. It's not a problem, especially when people are leaving and that kind of stuff. Just be sure that you give the person who's signing on their behalf lots and lots of presents, because it's a total pain in the butt to sign loan documents with a power of attorney. So there's my.
And the other question, what if the power of attorney has a social security number listed on it? Can the social security number be blacked out?
Yes, it can. And actually, that's something that the recorder's office requires. They don't want personal information to be listed on a document that is public record, especially since it's a power of attorney. And with a power of attorney, the person also, that's another thing we need to touch on, is the person has to be alive.
Oh, yeah.
So
once you're dead, the power of attorney's dead too.
Yes. So it is important for us to protect the client's information. Again, with documents that we draw, we do not list a social security number on it. It's very specific only to our transaction. But with a general power of attorney, sometimes the templated power of attorneys that you can find online or that attorneys or paralegals use, it will list the client's social security number or home address, things like that. We have the ability within our recording system to be able to black out those items so that we don't alter the original document, but we don't want to make that a social security number or someone's address like that public record. So we do protect the client's information in that sense.
Okay, there are no more questions in the chat.
I got a question.
Okay.
Can I just ask?
Of course.
All right, so I am dealing with a client right now, and this scenario is the mother passed away. So he's saying that he is wanting to go to the court and file administrative paperwork so he can become the administrator. But we're concerned about timelines because the courts are backed up right now, and I'm not familiar with it. So is there any similarities as far as mutually inclusive documents or the process as far as being an administrator or being a what we're talking about today, which is a power of attorney, because the mother's passed away?
So since the mom has passed away and I'm assuming she's entitled by herself, correct?
On title by herself, yeah.
Okay, so in that sense, because there isn't anyone if there isn't a trust, then you would have to go through the probate process. Unfortunately, it does take time. The last one that I had where the clients, we found out about the person who is entitled is deceased. It took them about 6 months to be able to go through.
And that was before COVID.
Yeah, that was at like the beginning of all of this. So it took about 6 months for them to be able to go through that process and to have someone appointed to sign on behalf of the person's estate. Now, this also goes into a whole other thing. They do need to consult with an attorney to see, there are other options is what I'm getting at though, because depending on the size of the person's estate and how many heirs or beneficiaries there are, they may be able to record what's called an order determining succession to real property. And you can take down our information. You can call us after the class and I can go into this a little bit in more detail for you, but it allows for the property to be transferred over to the beneficiaries. And the process overall is just faster, but that depends on the size of the person's estate and how much property that they had. So that's the other option for, it's still a type of probate, and you still have to go through the courts, but it's just
Of
a little
course.
bit, it's just a little bit different than having someone appointed as an administrator for the estate.
Well, he's under the assumption that he would simply just go to the court and become administrator in a couple of months. But it sounds like what you're saying, there are a few other options, but probate is really going to be where they're going to have to handle that at.
Yes, correct. Because they
Yeah.
still have to go through the court process, and a judge has to sign off on it and either vest the property through to the beneficiaries of the estate, or someone signs on behalf of the estate.
Okay.
Christy and Love, do you have any situations where you've discovered that a power of attorney is a fraudulent document or had to turn that document down for any reason? Is there something our clients might be looking for as they go to a listing appointment or working with a client on things that might be a red flag for them or for us?
I personally have not had someone present to us a fraudulent document. I have had people present copies to us, not knowing that they needed to give us the original, and them themselves not knowing that they didn't have the original. They thought it was the original document. There's ways that we can tell if it's a copy or if it's an original document. I've run into a situation where the son and the father had the same name, and the son was signing on behalf of the father. This was not known to the agents. We realized this afterwards because I had a title issue and I started comparing signatures, and I said, well, wait a second. So why is this signature not matching with the current signature? It was drastically different. So but I haven't had anything where it was a fraudulent document. But
So,
Christy,
so what I'm gonna say is that it would be the best scam of all times.
Mhm.
If you guys didn't realize that this was a fraudulent document and you went through the whole process not realizing that what you had was incorrect, not realizing that the person who signed the document was not the person who owned the property, not realizing that the person who got notary or was the notary had their notary stamp stolen, so the bottom line is that if the people are, we don't, there's no way for us to check and see if somebody, if they're outside of Fresno, if they're deceased or not. That's why we do all of this extra checking.
Mhm.
Again, we're here to protect the customer. We're here to make sure that the actual seller is the one who's selling the property. So, you do have to be on alert, especially when you're not dealing with the customer directly at all times. So
They're saying, just like what Christy was going into, if you have someone who is from out of town, you don't communicate with them, you haven't met them in person, everything's through email or text messages, these are kind of red flags, and these are the types of things that we look out for. We know everybody's busy. We know there are people have things to do, things to get done, but when it comes to your real estate transaction, we do require for you to sit in front of a notary and present documentation to prove that you are the person who is supposed to be signing these documents. So we go through those steps, but is that to say that our company has never run into a situation where someone was pretending to be someone who they're not? Yeah, that happens, and that's where our claims department will come in and claims get filed. And that is why all of these requirements have been put in place, because at some point or another there was a claim that the company had and we had to pay because we did not take the appropriate steps to protect the customer. And if we let things just slide by, then it puts everybody at risk. So that's the reason why there are pretty strict guidelines when it comes to using a power of attorney. And again, as we mentioned previously, it's not that we're trying to make anyone's job difficult. So we do want to make this process as easy and as seamless as possible. But when there's extra things like a power of attorney or a trust or people are deceased, we do have to go through those proper measures in order to make sure that we have all of our ducks in a row and we have all of our documentation to support what we're doing and why we're doing it.
All right. Are there any other questions that anybody had for Christy or Love on this topic?
I have a quick question.
Yes, Dominique.
Can you hear
How
me?
can we help?
Okay.
Yes.
Hi. So when the customer takes the power of attorney to the consulate, is there a specific name for the appointment that they are needing to schedule? You said in some countries it's, you know, they're not taking these type of appointments. What's the type of appointment that we're looking for?
So when a customer goes to the consulate to make an appointment, I've actually gone online, and you can, depending on the country, you can set appointments online, and it gives you various options for what it is that you're trying to do. So they would set up an appointment for a notarization, and at that point, sometimes the countries, they'll ask what document it is that you're notarizing. Most of the time they don't, but it's just a simple notarization appointment. Now, with a customer that I've had in the past, you know, they were in India, and the consulate there in India, they weren't accepting appointments for notarizations. They were accepting appointments for other types of things, like emergency visas and things like that, but a notarization was not on their list of things. So the notarization is what the appointment would be for.
Thank you.
You're welcome.
I have a question. You guys said something earlier in your talk that I don't think I've ever heard before. And that is, you guys do a really good amount of due diligence into a notary. The question I had is, are there particular notaries that if you guys see them stamp a particular power of attorney, that it's a huge red flag? And then what do you actually have to do about that? Because I'm sure that there might be some that actually fall into that category.
So when we are going through the process of vetting a power of attorney, if the notary is no longer an active notary, then that's a little bit of a red flag. However, when it comes to the person who notarized the document, there are certain notaries that are on the list and are approved. There's other notaries that aren't approved, but we will still accept the document. We do have to go through our corporate department and management in order to have the notary approved for a one-time use for the document. And that goes for other documents as well in our transactions. You know, we have customers who, you know, we can't find a Chicago title approved notary in the area that they live in. So we'll ask them to go to a bank in order to have the document notarized, or they can use a local notary, but that notary has to go through a process to get a one-time approval. As for what corporate does for going through that process, I'm not 100% certain on all of those details. I do know that they do check out the notary though, and if there's a reason for them to not want us to use that notary, they will tell us. I personally have never had that happen, so I can't necessarily speak on what would happen. We probably just wouldn't accept the document, and we would need it to be re-signed and re-notarized.
So it's not uncommon. A lot of times things that do fly fairly easily is when a notary is being done under an attorney's umbrella. You know, so there's so many things that we're looking for to make sure that the consumer is being protected and that the right documentation was taken.
All right. Glenda Green just mentioned that we had a 45-day escrow turn into 5 months due to the seller being out of the country with the consulate closed. So just kind of a little story that she shared. I think that if there's no more questions, we are ready to conclude this. You'll see our sales team's contact info up on the screen, and you also had Christy and Love's info for a bit. But thank you everybody for taking the time out today. We did record this, and so we'll be sending this out to everybody. And if you have any additional questions, don't hesitate to reach out. Thank
And
you
there's one
so
more
much.
question. There's one more question.
One more? Okay.
Yeah.
Okay, so the question from Jessica is, does the power of attorney for a seller need SIs along with the seller filled out? So we do not run the customer's name who is signing on behalf of the seller. So for example, if Christy's the seller and I'm signing on her behalf, I really have nothing to do with the transaction.
She's not me. She's just pretending to be me, basically.
So I don't have anything to do with the transaction. We're not using my forwarding address. We're not using my social. We're not running my name. If I had liens against my name, like those are not going to come up in the transaction. Now, if you write your contract in a manner though, where, you know, I'm selling Christy's home and my name is listed as an individual who is signing, then when we open the order, we would open it under my name as the seller. Later on, we would find out.
Yeah.
But the title report may come back originally with saying like, oh, Loveneet Bains, we need an SI on her. So that can happen. And that's really the only instance where I could see you ever seeing a requirement for a SI on someone who's not necessarily the
But
principal.
we would take it away. It would not be a valid request, basically.
Exactly. Right. So, and this also applies to successor trustees. So if I'm signing on behalf of Christy's trust, the same thing applies. I'm only the signer and I'm only acting as a signer on behalf of someone else or for the benefit of someone else. So again, my social security number, none of that would be tied to the transaction. It's completely separate. You're only the signer when it comes to signing as a power of attorney or as a trustee for someone else's trust.
And remember, we recorded this, so you guys are going to get an email with this from Jennifer with our once it gets to YouTube, and you can look at any of our other classes on YouTube. We have a Chicago Title Fresno YouTube channel with all of the classes we've taught.
One more question is in there. Jessica, what happens in the event that the seller passes during escrow? We have actually had this happen a couple of times. The first time that it happened, it was right in the beginning of the transaction. And unfortunately, the customer had to cancel the escrow because the clients needed time to be able to go through the probate process. We've had other transactions where, you know, the customers come to us and they say, oh my gosh, I'm going to go into surgery and I might not make it. That has been a thing as well. And we go through, we'll prepare all of our papers, get everything signed. If all of the documents are signed, then you're good. If you need one more document at the end of the transaction though, then you're not good. So it just depends. If they have signed everything and then passed away, then we're okay. But if they haven't signed anything, then you would have to go through probate, or if they have a trust, then we would need a death certificate and for the successor trustee to sign. So that's what would happen if they passed away during the transaction.
Okay. That's all we got.
All right. Thank you
Thank you for
all.
joining us,
Thanks, guys. If you need anything, we're here for you.